All right, welcome back to Senate Judiciary. I will call the meeting to order. Will the secretary please take the roll?
Senator Harris. Here. Senator Orenshaw. Here. Senator Don Darrow-Loop. Senator Nguyen. Senator Hansen. Here. Senator Krasner. Here. Senator Stone. Here. Chair Scheibel.
Here, please mark any senators who are not yet present when they arrive. We have one bill hearing on our agenda for today. I think most of you are pros at this by now, but just in case we have anybody testifying for the first time, I'm going to give you a brief outline of how this goes. The bill presenter will present first, and at the conclusion of the presenter's presentation, the members of the committee will be allowed to ask them questions. After that, we will move into testimony. We'll take testimony in support, opposition, and neutral on this bill, and then we'll have the sponsor come back up to make any closing remarks, answer any questions, concerns that may have been raised in the course of the testimony. If you are testifying in person, there is a button in front of the microphone. You do have to press that button and turn your microphone on. Even if you project really well, nobody can project from Carson City all the way to Las Vegas, and so the microphone is how we get the audio down there. Each person giving comments will have 2 minutes to speak, and you need to put your name on the record before you get started. I do keep time, and I will ask you to stop at the end of the 2 minutes, and then you don't have to ask me for permission to start. You can just fill in the seats as they become empty to give testimony, and like I said, at the end, the sponsor will come back up and give us some brief comments. So. We are happy to see people engaged in the process, look forward to hearing from all of you, and we will start by opening the hearing and inviting our sponsor, Senator Spearman, to the table to, along with any co-presenters she might have with her, it looks like she has a few, who she will introduce to us, and you guys can get started whenever you're ready.
Good afternoon, Chair Scheibel and committee members. For the record, I am Senator Pat Spearman, and I'm pleased to come before you today to present Senate Bill 175, which continues my ongoing work to ensure that our laws governing Nevada's homeowners associations are transparent, effective, and fair, and that they help Nevadans retain what is likely their most valuable investment that they will ever make. In recent sessions, the legislature has done a lot of work to revise HOA laws to protect both homeowners and to improve the way HOAs operate. In 2021 alone, we passed such bills as AB 237, 249, 301, SB 72, SB 186. Senate Bill 175 continues that work by putting in place further protections for our most vulnerable homeowners, ensuring that HOAs can be held accountable when they ignore the law. I have several persons here with me today who will speak to various provisions of the bill and why they are needed. But before we get to that, I would like to provide the committee with a quick overview of the bill. While 175 contains several sections, it actually addresses 4 main subjects. Number 1, lien foreclosure, repair of common elements in an HOA, when an HOA can be terminated, and when a homeowner can be awarded damages when an HOA fails or refuses to follow the law. First, Section 2 addresses the foreclosure process relating to a lien that an HOA holds for an amount that is owed to it by the homeowner. If the homeowner, his or her successor in interest, is a member of a household, or a member of the household is a veteran, a senior citizen, or a person with disability, this section forbids an association from initiating a lien foreclosure by sale and instead requires the association to go through the judicial process as set forth in Chapter 40 of our NRS. And let me say that again. The judicial process that is already set forth in NRS, in Chapter 40 of NRS. So this is not something new. This is something to make sure that some of our most vulnerable persons, and this is their most valuable asset. And let me just say this, there'll be a number of people who will come and they'll say things like, well, your homeowner dues are going to go up, or this is that and that, but the people that we're talking about here, we're talking about veterans. Less than 1% of the population today has ever served in the military. Less than 1%. And these are people who signed on the dotted line to protect our country. This is one of the least things that we can do, help them stay in their home. The other vulnerable population are those that are 62. 62 years old, and if they don't have these protections and they lose their home, right, tell someone 62, go get a 30-year mortgage. Okay, so this is one of the reasons why we're bringing this, and someone who is differently abled. So I'm not talking about millionaires, gazillionaires. I'm not talking about somebody who has lawyers on retainer. I'm talking about some of our most vulnerable people. And let me be clear. This is not personal. This is about people who need our help. And I believe that the laws of this state, and indeed the laws of the country, should be about protecting our most vulnerable. And as I said before, veterans. Really? 62-year-olds. Really? Someone with disability. Really, really? Oh, no. So the section goes and sets forth a procedure on an HOA that they must follow and may be subject to foreclosure, the existence of these provisions, and to allow the homeowner to provide information to verify that the homeowner or a member of the household is entitled to these protections. Alternately, if a homeowner does not provide such information, the association is still required to make a good faith effort to verify whether the person is entitled to these protections before going forward with a foreclosure. And that's just a simple matter of asking either when the homeowner joins the association or asking before the process is initiated. I don't think that that's too cumbersome. A person who initiates a foreclosure in violation of these provisions is guilty of a misdemeanor and may be held liable for damages and attorney's fees. And finally, the section requires each association to report annually to the Real Estate Division information on how many foreclosures have been commenced against persons who are entitled to these protections under this bill. Similarly, Section 11 requires that the collection agencies also ask homeowners to provide voluntarily information on whether they are entitled to the protections afforded by Section 2 and to report that information to the Real Estate Division annually. Section 8 of the bill creates a required notice to a potential buyer that the protections set forth in Section 2 exist. Second, Section 3 of the bill provides for the timely repair of common areas and security walls in an association. Let me read that again. The timely repair of common areas and security walls in an association as soon as possible, after being made aware that the repair is needed, rather than the current language which states within a reasonable length of time. It also provides that the Attorney General may take legal action against an association that fails to comply with this provision and allows for the district court to issue an injunction or grant other relief to compel an association to comply with the law. Third, Section 5 lowers the threshold to approve the termination of an HOA from 80% to 60% of the homeowners or the unit of the homeowners to vote the association either in or to cancel that relationship. And Section 9 contains new provisions that allow damages, special damages, and punitive damages to be awarded to a unit owner in a suit against an association where the failure or refusal of the association to comply with the law caused the unit's owner to suffer personal injury, death, damage, or damage to property. This concludes the summary of my bill, Chair Scheibel, and I would like to now turn it over to some of my co-presenters, and not at the table with me is Mr. Andy Philbert. Where is he? And he will be coming forth to speak on behalf of our veterans. But I'll turn it over now to Assemblywoman Claire Thomas, an Air Force veteran. And again, I say I'd like for you all to please listen to this with fresh ears, because we're talking about our most vulnerable people. These are people who don't have attorneys on retainer, who can't afford 6 or 7 figure attorneys. These are people who are just trying to hold on to their homes the best way that they know how.
Good afternoon, and thank you, Chair Scheibel and Senate Committee. I appreciate coming forth on this bill. I want you to know that I really do support it. As a retired Air Force veteran of 20 years, most of my time was spent at Nellis Air Force Base, so seeing the homeowners associations develop in our city of Las Vegas, I must say that when I saw the bill and read the bill, I was taken aback because, number one, we have to have a bill like this. There should not be a bill like this. We should respect and honor those that have served willingly, voluntarily in our service, and for us to look at our seniors and not respect and develop and care for our seniors, and our disabled, the same difference. This is a compassionate bill. This is a bill that takes us to the point that some of our service members are seniors, some of our service members are disabled. So we have to look at all of that and consider something that we have valued, and that's our home. I am a homeowner. I live in an HO community, and I think that for whatever violation that might occur, for someone to come along and take my home, something that I've worked for, that am entitled to, and I deserve, frankly. I think that that would be something that would be egregious in our 21st century. We actually have to learn to respect, and respect our service members, respect our seniors, and respect our disabled. And I really do not believe that this bill hurts anyone. It enhances those protections that apparently we need. So thank you so much. I appreciate the time that you took to listen to me. Any questions?
We'll go ahead and hear from the other presenters and then ask questions. Yeah, go ahead.
Chair and committee members, my name is Andrew Lee Pilbit. I'm the chairman of the United Veterans Legislative Council, and we're in support of this because it takes an extreme foreclosure capability and reduces that down to an actual judicial process, which affords some of our seniors and our veterans a greater opportunity to correct their situation. And when you have an immediate foreclosure capability on a lien, let's just to give you an example of a lot of our older citizens and veterans have significant equity in these homes. And it seems really wrong that an HOA could just flip it for a $10,000 bill they may owe or something like that in assessments. So we like the slower process that helps our veterans. And that's why the United Veterans Legislative Council is supporting this. Thank you.
Jonathan Norman, Nevada Coalition of Legal Service Providers, so that's Legal Aid Center, Northern Nevada Legal Aid, VARN, and the Senior Law Program. I think that, we already have an analogous process in Nevada for judicial foreclosure in like an extraordinary circumstance, like with the HOAs. Republic Services has the ability to foreclose on homeowners. The difference is it's a judicial foreclosure, and that allows for legal services to get involved and to potentially make a difference. It allows for, if there's court mediation programs, to get involved and make a difference. And when we talk about veterans, seniors, and those who are differently abled, the resiliency potential if they have significant equity in their home. And I was in a hearing the other day where, and I'm forgetting his name, but the gentleman who was to my right testified about our aging veterans population. And for those people to be at risk of losing their home in a very fast process, I think really puts our community in a bad position relative to those most vulnerable people, but also people who have served. So I appreciate the committee hearing this bill, and happy to answer any questions.
Sophia Romero, for the record. In my career, I've spent over a decade working to protect the most vulnerable Nevadans. This bill furthers that goal. HOAs often engage in abusive practices, and asking HOAs to go through the judicial process, especially when it comes to the most vulnerable in our community, such as the differently abled, such as veterans, such as seniors, is not too much to ask for them to do this. They will present with you a sky is falling approach, that everybody's HOA's dues are gonna go up and this is gonna be horrible for everyone. This is not the case. As the senator talked about, we're looking at a very small number of people. We're looking at elderly who tend to have a larger amount of equity in their home. We're looking at disabled people and we're looking at veterans. So this is not a sky is falling scenario. I just wanted to let you know that this bill actually, as Mr. Norman just said, is it not asking for anything new or different to be done. It's just asking the HOAs to follow processes that are already in place in Nevada. Thank you.
Thank you, Madam Chair. I'll stand for questions at this time, or we can go to support, however you want to do it.
I think we have a few questions up here. So I will start with Senator Nguyen.
Thank you, and thank you both for this presentation. I'm gonna start off by saying that I 100% appreciate the intent, and I understand the problems that we have on some of these foreclosures. And this might be a legal question that I see you're still sitting there, so that's great. I just, as a lawyer, I know lawyers are going to lawyer, and it just concerns me because I know that while some of these will be able to receive representation from legal aid or other like nonprofit agencies or organizations that would provide this type of thing, but making it go into that judicial foreclosure system, I'm just really concerned that it would be a situation where people would have to get a lawyer. That means the HOA would have to get a lawyer. And I'm not so much concerned about the HOA and the fees and that kind of like rhetoric about it increasing amounts for HOAs and other residents. But I am concerned that if you're not successful with like that judicial foreclosure, that somehow our veterans and seniors will now somehow be responsible for those attorney fees when they lose. Not only will they lose their house, but they will also be in debt for the attorney's fees for the prevailing parties. So if you can kind of address that, that would be great.
Jonathan Norman for the record. So I'll answer that in two parts. So as a legal aid attorney and just a Nevadan, do I think, and this may go beyond the scope of this bill, but should, whether it's an HOA or a utility like a garbage company, be able to foreclose on someone's home altogether in any manner, I find repugnant. I think that having a lien and having that satisfied at the point that how home is refinanced or sold should be sufficient. But that goes kind of beyond the scope of the bill and your question. As far as how we see this play out with Republic Services, so when the mortgage company, when there's a mortgage involved, which is in most of the cases, the mortgage company is involved and they satisfy the lien, and then they are adding, because they're protecting their asset, and then they add the amount, the lien costs onto we see it added onto the escrow amount, and that can be 6 to 12 months. And then typically we find that the homeowner can ask for an extension, and usually that is granted. So I do understand there are risks of having more attorneys involved, and are we creating a scenario where attorneys are winning, right, instead of our most vulnerable Nevadans? But I think when you have the judicial process more engaged, you have more light on what's going on, and there's more opportunities to protect vulnerable people.
But that would still be the case. They would be responsible to pay the prevailing parties' fees if they were unfortunately unsuccessful in this scenario. Is that correct?
I think that is correct.
And I recognize the problem that you said from the outset, and I'm just concerned that the consequences of this bill or the intention of this bill doesn't solve the initial problem that you talked about foreclosures and by garbage companies and HOAs in general.
And if it's okay, I think Sophia Romero has litigated in this space, so I think maybe she could have shed some more light than I have.
I knew there were enough lawyers in the room.
As you said, Senator, lawyers are going to lawyer. Again, Sophia Romero for the record. So I am a private consumer rights attorney. I have not always been in the private space. I was a legal aid attorney previously. But obviously, private attorneys do take these type of things on contingency fees. Obviously, that's only one half of your question. You're talking about what happens if they are unsuccessful at the end. Attorneys' fees can often be negotiated. Additionally, if the house ends up being foreclosed on, there are other protections already in place in Nevada law. So if somebody is only getting Social Security disability, for example, they are protected under our wage garnishment, or under our garnishment statutes. So there are protections in place for people who are already kind of at the most vulnerable. So if they aren't successful, they are already protected under our laws.
I guess I also just have concerns because I know legal aid does like such amazing work, but I know that they are only doing a percentage of like those cases that are out there. And I would just be concerned if you have a situation where someone maybe can't get a legal aid attorney to do this work for them and they can't find an organization to come and do it on a pro bono basis. Does this leave that homeowner, that veteran, that senior having to go search out for an attorney to represent them in this space now because it's a judicial foreclosure? Or do people routinely, do you anticipate them representing themselves in their own pro se like capacity?
Well, in addition to legal aid services, there's also private consumer attorneys who handle this type of work.
And if we could have your name for the record.
I'm so sorry, Sophia Romero for the record. There are private attorneys who do handle these type of claims.
Other questions from members of the committee? Senator Orenshaw.
Thank you very much, Chair. I think my question might be either for either of the two attorneys, just kind of a question. In your experience right now, when you represent veterans and senior citizens who live in HOAs and are in this situation, are you finding that they're able to work things out with the HOA, or that things are going on a quick pace towards a foreclosure? I just wonder, for those who are in the trenches representing seniors and veterans, what are your experiences? Thank you, Chair.
Usually we do attempt to negotiate. Obviously, we try to do whatever we can to keep a homeowner in their home, especially when we're talking about being foreclosed on for fees and, late dues and stuff like that. So we do try to negotiate to keep a homeowner in their home as much as possible. That is the number one kind of tactic that we go to. That's the default. And I'm so sorry if that didn't answer your complete question.
No, I think that did. And are you finding that is successful, or sometimes are you not able to resolve this and it does go forward with foreclosure?
Sophia Romero for the record. It kind of is just a case-by-case basis. It has been successful. There are cases where it hasn't.
Okay, thank you, Mr. Romero. Thank you, Chair.
Other questions from members of the committee? Senator Hansen.
Just trying to learn a little bit more about this. Thank you, Madam Chair. This would have to go to a district court? This is not going to be small claims or something like that, correct? When you say you got to take it to the judicial side of things, you have to get a lawyer to be in small claims, in district court, correct?
Sophia Romero for the record. You do not have to have a lawyer if in district court. Two-part question. Your first question is yes, because this concerns real property, it would be in district court. Second part of the question is you do not have to have a lawyer in district court. The only entities that have to have a lawyer are corporations, LLCs, those type of things. They have to be represented by an attorney. An individual can be in district court as a pro se litigant.
I assume that's exceptionally rare, especially if we're talking about the most vulnerable people. I mean, if I was to say, well, ironically, I'm 62 this year, so I now qualify. But typically, you wouldn't advise people who have no legal experience to go into a court situation without legal representation, I assume.
Sophia Romero, for the record, I always advise people to get a lawyer if they're going to be in a court situation.
I got it. Well, that's what I thought. The only other question, I'm looking for an example of an egregious violation of the current system. I mean, you guys have obviously been involved in that. Can you think of cases where HOA has actually, abused the privilege of doing a foreclosure or a lien or however they do it currently?
Sophia Romero, for the record, absolutely. I've seen people where their houses were completely paid off and they got completely foreclosed on over $3,000. And their house was paid off.
All right, that's what I'm looking for. I want to see, some real life situations that we're trying to solve here. Because, I've got the HOA people talking to me. Senator Spearman and I were discussing it just yesterday. And so I'm trying to kind of learn what the problem is we're trying to solve and how big and how egregious is it.
Senator Hansen, I could also, Jonathan Norman for the record, I could also connect you with an attorney at our office who is the primary lead on handling these cases, and he can walk you through what we see, day in and day out on these cases.
Good. Well, I'm going to listen to the testimony and see. And so, yeah. But, HOAs, like, I'm not joking. Around here, I call them the bills from hell because HOAs are always a pain in the butt. And I feel bad for the HOAs and the people because you have to come to the legislature. We meet, 120 days every 2 years. This is a constant, ongoing problem with so many. There's thousands of HOAs now. And they all have issues. And it just seems like this should be being handled at the county or city level. But I know, I can see the chair glaring at the corner of her eye at me. So, no, you agree? Good. We're going to talk about that, bringing back 116 again. So, anyway, thank you very much. And If I don't get the answers that I want, I will come track you down. I'd like to talk to somebody who actually specializes in this area. Thank you, Madam Chair.
Yeah, Madam Chair, Senator Spearman, for the record. Senator Hansen, I could go back through some testimony of last session where we had a woman who was fighting cancer, and the plumbing in her condominium, it was already paid off. She used some settlement money to pay off her condominium. There was an issue with plumbing. And her testimony was that there was second-degree waste, and I think it's basically feces, coming up through the sink. And she had it fixed. The plumber said, this is not your problem. This is a problem with the plumbing in the building. But she had it fixed because the HOA didn't step in to do anything. And it cost her several $100s, and she said, when she sent the bill to the HOA, they said, well, it's not our problem. And the plumber had clearly stated in the comments of the bill that this is a part of the plumbing system. And she called me when she saw the bill, the HOA, and asked me if she could talk about it. And I said yes. When she came to testify, I believe she was in the second portion of perhaps maybe losing her home, and she's crying. She said, I'm fighting cancer and I'm fighting my HOA because the only thing I did was I withheld my dues to make up for the money that I paid. There was someone else who also testified last session that they submitted a request to paint their home, and the request was not acted upon in a timely manner. And so they went back and they said, well, are you going to do this? And basically, said, well, we'll get around to it, or words to that effect. And the person went through the neighborhood and looked at some of the houses that had already been painted and found someone who had painted the homes the same color that some of the homes in the neighborhood were already painted. And the HOA came to her and said, because you didn't get our permission, you have to repaint the house, or we're going to continue to fine you. Now, I live in an HOA, all right? I know a lot of people who won't buy a house if that's the case. But I'm pretty sure that if you asked 500 people, do they have some kind of story, either personally or second or third consanguinity, they would probably be able to tell you that. And again, this is something that is designed to protect the most vulnerable. And to Senator Nguyen, to your question, the protections that are in place with this bill, there are similar protections in place for consumers. If you have to go to court, do you have to get an attorney? But the real answer is this: if these protections are not in place, then the homeowner has nothing. Nothing. And so this bill may not be perfect, but I would ask the committee and those who are listening, do not let perfect be the enemy of good. We have people who are losing their homes, and there are some veterans organizations that if they know this is happening, they will step in and pay those fees. You also have the foreclosure mitigation, that Jonathan talked about earlier. You've got that. And so there are other remedies, but without a bill like this, and you'll probably hear the HOA say, well, it's going to be, we're going to have all of these. Well, how many are you foreclosing on right now? And if you're foreclosing on a lot, then that's further proof that this bill is needed, okay? And if it's a small amount, it's a small amount, but there are still veterans and seniors and those who are differently able who are able to stay in their home. And I don't understand any mindset that says it's okay to foreclose on a veteran. A combat veteran, he'll be real with me. Someone who's 62, who struggled. The woman that I talked about was fighting cancer. Her condominium was already paid for. And here's the real reason why I bought this bill. That I had a veteran, and I kept trying to find him. 2 veterans called me during the interim. One called me because he was looking for housing. And he said, I had a house, but I ran into some problems with my HOA, and I wasn't able to pay the fees. I said, what are you talking about? He said, well, my home got foreclosed on. I said, what are you talking about? He said, my home got foreclosed on. I said, what are you talking about? He said, my home was foreclosed on. And there was not anything that I could, quote, do for him. Someone else called, and I did find them, but they asked that their name not be mentioned because a lot of people, they don't want to come forward and give their name or their address because they're afraid of retaliation. And that right there should tell you something about the way the system is right now. But he called me up and said, Senator Spearman, I'm going to buy the farm. I said, no, you're not. What's going on? And he told me he was in a heated battle with his HOA, and he could not pay the fees. I sent him to a couple of places and said, will you just ask them if they can help you? Go to legal aid, and I knew we had some type of foreclosure mediation or eviction procedure in place. I said, don't buy the farm. He's a combat veteran from Vietnam. That's the only reason I'm here, with having another, session with an HOA bill. Okay? Do I like getting beat up about the head, neck, and shoulders? No, I don't. But for veterans and for seniors, and for those who are differently able, I will go to hell with kerosene underwear on and fight for them and come out alive.
Other questions? Senator Stone.
Thank you, Madam Chair, and thank you for your presentation, Senator. Nobody's going to question your dedication to veterans, and I appreciate your passion for them, and I share that passion with you, and I share that passion for the disabled population, and I share that passion for the elderly population, and it's exemplified by 28 years of public service. And whether I support or don't support this bill is not going to abrogate my support for these organizations. When you buy a home or condo in Nevada under NRS 116.41095, it's a form that has to be presented to a buyer, and they get it immediately. They have to be presented with this document immediately when escrow is opened. And what this mandates is it mandates that a owner will understand what it means when they go into a managed HOA organization. And this is so important that after a prospective buyer reviews this contract, they can actually cancel the escrow and get their complete earnest deposit back if they cancel within 5 days of reading this comprehensive document. I just want to read just a few things about it. One, it says you generally have 5 days to cancel the purchase agreement. The law generally provides a 5-day period in which you have the right to cancel the purchase agreement. You are agreeing to limitations that it could affect your lifestyle and your freedom of choice. You will have to pay owners assessments for as long as you own the property. You are responsible for paying your share of expenses relating to the common elements such as landscaping and the amenities and the operation of the HOA. The obligation to pay these assessments binds you and every future owner of the property. The executive board of the association may have the power to change and increase the amount of the assessment to levy special assessments against your property for unforeseen things to meet extraordinary expenses. And the fourth provision is if you fail to pay owners' assessments, you could lose your home. The association usually has the power to collect them by selling your property in a non-judicial foreclosure sale. If fees become delinquent, you may also be required to pay penalties and the association's costs and attorney fees to become current. If you dispute the obligation or its amount, your only remedy to avoid the loss of your home may be to file a lawsuit and ask a court to intervene in your dispute. So in either scenario, whether it's a non-judicial foreclosure or a judicial foreclosure, if a owner wants to save their property, of course they can represent themselves and go pro per, but that certainly wouldn't be the advice, I think, of anybody that's an attorney on this dais. They're still going to have to put up the money for an attorney. So everybody gets this. Now, why is that important? The HOA maintains the health and safety of the community by making sure the landscaping is taken care of, making sure the gyms are clean and that the toilets are taken care of. They may have security that roams. They may have a security gate that needs maintenance. They have a lot of other responsibilities. And I believe that a good association, I'm not going to tell you there's not some bad associations out there, but they actually maintain some of the great values that people have been realizing in real estate in the past few years. So I have great concerns because if we're creating a separate class of members of this corporation, if you will, and certain owners that don't pay their assessments, and they're going to be looking at a more expensive and a prolonged way to get those assessments so that the remainder owners don't have to pay higher fees to pay for the same. And we've certainly seen fees go up because of inflation. Utility rates have gone up. A lot of times your water is included in your HOA bills, so things go up. People get mad at the association for raising their fees. And I'll also add this, that many of us think that what we do here is a thankless job. Being in the legislature, probably more of a thankless job is being a member of an HOA association member. It's a thankless job. But the bottom line is that they do serve a purpose. And obviously, another thing I'm going to ask of the attorneys. In a non-judicial foreclosure, let's say somebody has $10,000 in fees. First of all, it's not like a month after the fees are owed or 6 months after that you immediately go to a non-judicial foreclosure. There are many hoops that you have to jump through. And I know because my wife's a HOA board member, and it takes sometimes a year or even longer to even reach the phase of where you go to a non-judicial foreclosure. And if you do a non-judicial foreclosure, you're going to get your $10,000, but it's my understanding that the property owner is going to get the residual, whatever the fees and everything else adds up, taken out, they're going to get the net proceeds. My question is, in a judicial foreclosure, if a bank, let's say a bank is coming forward, or let's say an HOA is coming forward, and it's a judicial foreclosure, does the property owner still get the difference, or does the HOA or a bank, if they're foreclosing on a mortgage, get to keep all the proceeds of the equity that's in the home?
Jonathan Norman for the record. So a couple questions there.
Yeah.
So if the judicial foreclosure, if there is a bank that has a mortgage, right, they're going to, so the HOA would be getting their $10,000 in your example.
Yes.
The bank would be getting the
back mortgage.
The whatever they're owed on the mortgage.
Yes.
And then, to Senator Wynn's question, there probably would be an assessment of attorney's fees, which would be paid to the HOA, and then the remainder would be the homeowners, if there is additional equity beyond the, beyond those three priorities.
Okay, so in a losing proposition, let's say somebody is being foreclosed on, it's a non-judicial foreclosure versus a judicial foreclosure. What is the biggest exposure for the property owners being foreclosed on? Are they going to pay more legal fees in a non-judicial foreclosure, or are they going to pay more legal fees to the other side in a judicial foreclosure?
Sorry, could you could you say that again?
Okay, so it's my understanding that in a non-judicial foreclosure, it doesn't take as much legal power, if you will, to foreclose. So hence I would assume that your legal fees would be less to the association and less to be billed to the property owner. With a judicial foreclosure, you have to hire attorneys to go through a judicial process, which is much more time intensive and probably much more expensive.
I think that, Jonathan Norman for the record, I think that is correct, but that is the case for every legal proceeding in our country that's civil. Your exposure as far as attorney's fees will always be more. And I don't think that that is an argument to have things be outside of the judicial process when it comes to something as significant as someone's home.
Okay, and then just one last follow-up question, if I may. A part of your provision is you can disband a HOA with a 60% of the vote of the membership versus 90%. Assuming that there's a rogue
80%.
association out there that are doubled the assessments, that one of the board members is embezzling funds, you want to get rid of this organization. So in the event that you disband an HOA, who then is going to be the successor in interest to make sure that the landscapers are paid, the gates maintained, the restrooms are clean, the gym is, the equipment is well maintained, the property taxes are paid, et cetera? Who will take over that responsibility?
So the process that would be in place for 60% is the same process that's in place for 80%. And if they do that, it's up to the homeowners to decide that. And Senator, you keep mentioning the gyms and gyms. Most of the people that are being foreclosed on, if you look at the zip codes that we collected last session and those zip codes that we looked at, those folks ain't got no gym. The gym is walking around the park. The gym is walking up and down the street. That's the gym. Okay? So, I mean, you know, I get that people who have a gym and who have swimming pools and have all of those things, I get that they need somebody to take care. But we're not changing the process. We're only saying lower it. And let me say that you had a piece of paper there that you said this is, can you read, what's at the bottom? That's in accordance to what? The paper that you read,
Yes.
How is that legal? That's in accordance to some law?
It's NRS 116.41095, required by NRS 116.4103 and 116.4109. It has to be given to the
I get it.
property owner at the time they
I
go
get
into
it.
escrow.
But here's my
The
point.
property buyer.
Here's my point. Those weren't established on the mount with the two tablets. And that means that our laws and things, some laws are made, and then once we figure out that there needs to be some changes, that's what we do. That's what we do. I appreciate that, you know, the 116, I appreciate all of that. But that's why we're here. That's why we're here. And you know what? Let me just say this at the outset. This is a really tough assignment. I have no illusions that we're going to get this all the way through. I have no illusions of that. Because, as I said before, you know, there's several people in this building who are getting paid a lot of money to make sure that this doesn't happen. But the people that I'm fighting for, that we're fighting for, are the people who ain't got no lawyer. The NRS wasn't a part of the tablets. We do this every session, several times a session. We look at the law that's in place, and we say, oops, we need to make some adjustments. Oops, maybe we need to eliminate that. Once upon a time, slavery was legal. And we figured out, that ain't the right thing to do, and we eliminated that. Once upon a time in Nevada, it was okay to pay women differently than you paid women, just men based upon gender. And we figured out in 2019, you can't do that no more. So we changed the law. So my point is, and I get that, and as far as when you sign the paper, everybody that signs a mortgage, and if it's for 15 years, 20 years, 30 years, or whatever, they have every intention of paying that mortgage off. But you know what? Stuff happens.
Yep.
Stuff happens. And when stuff happens, they try to do the best they can to make good on that. I stayed in a house 10 years here in Nevada, 10 years, losing equity. I paid $450,000 for the house, and by the time I left, it was only $137,000. But I stayed because my name was on the mortgage. Okay? So two things. Laws are passed, laws are altered, laws are changed. Okay? And the intention, when I bought my car, I bought it for X number of years. I have every intention of paying it off. But stuff happens. Stuff happens. And like I said, I have no illusions that this is going to get all the way through, because the last time, the Rock of Gibraltar came against the people. Okay? The Rock of Gibraltar came against the people. I hope that it does, because I hope that compassion will lead the way when people are debating this. We're not talking about not paying whatever it is that they owe. We're talking about a process that gives them an extra layer of protection. An extra layer of protection for veterans, an extra layer of protection for 62 plus, an extra layer of protection for the people who are differently able. So the paper, I respect that. If this gets passed, there'll be something else on that paper next time.
Senator, if I may, Sofia Romero, for the record, just to address some of the comments from Senator Stone. So as Senator Spearman mentioned, none of us have a crystal ball, right? When we all assume that we're going to pay, and many clients have, they've paid off their mortgages. The only thing remaining is these monthly HOA dues. Second, boards change. Boards are elected, they change. An HOA could be fined for the first 5-10 years of its existence, and then something happens. Second of all, going to the attorney's fees issue, you're automatically assuming the foreclosure. So in a non-judicial foreclosure, you're gonna get foreclosed on, bottom line. And attorney's fees will be less than that. In a judicial foreclosure, there's a chance to stop the foreclosure. The foreclosure is not a necessary outcome. It's not a foregone conclusion or whatever the saying is. You have a chance with a judicial foreclosure for that homeowner to get in there and say, no, 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 this isn't right. This is what happened. You have the chance to explain to somebody that the only reason they were withholding dues was because they paid for the plumbing to be repaired. There's a chance to stop it. So whether the attorney's fees, if a judicial foreclosure goes through, if the attorney's fees are higher, the attorney's fees are higher. But at least there's a chance that the foreclosure could be stopped. And that's what this bill is trying to do here.
Can I respond, Madam Chair?
If you have another question.
Yeah, so can't a homeowner in a non-judicial foreclosure, if they think they're being inappropriately targeted and foreclosed upon for unrealistic reasons, can they not then hire an attorney and stay the process until that lawsuit is heard?
So essentially what you're asking is if the process can be inverted and then the homeowner would have to sue the HOA to stop the foreclosure. So, I mean, yes, that's an option. A lot of homeowners don't know that's an option. They think they're being foreclosed on. It's out of their control if they're.
It's disclosed when they bought the house. It's disclosed.
How many pieces of paper do you sign when you purchase
It's
a
an
home?
important one. You got to sign it within 5 days. Thank you.
Exactly, but for anybody who's bought a home, who read every single word of that document, right? So, I mean, I'm a lawyer, and I got through maybe 3/4 of it, and this is what I do on a day-to-day basis. So we're talking about elderly people, we're talking about veterans, we're talking about differently abled. This layer of protection should be in place. Honestly, we shouldn't even have to be here to do this, but for these groups, for these people, this layer of protection needs to be in place.
Other questions from members of the committee? Let me do a first past first. Okay, Senator Hansen.
I'll be brief. Thank you, Madam Chair. Honestly, Senator, I love your passion, by the way. It's always a pleasure to have you in front of a committee. I think we're on the same page as far as wanting to protect people. Our concern is that we may make it worse, is what I think Senator Wynn's kind of getting at. So just so you know, look, we want to protect veterans, seniors, disabled people. We just want to make sure that in the process, we don't end up actually giving a greater cost to the process than what they would currently be forced to pay. So just so everybody knows, we're not against. Last thing I want to do is have senior citizens or veterans, especially combat veterans, kicked out of their homes. But on the other hand, I don't want to create a process that could potentially actually make it worse. So just want to get that on the record, just so you know where we are on this thing, because you and I have discussed it, and you know where I am on it too. I'm certainly no fan of HOA boards, Yeah, there's some great ones, but yeah, there's some horrible ones too. So anyway, I just want to make sure everybody understands that as we go forward in this process. Thank you, Madam Chair.
Can I respond to that, Madam Chair? Senator Spearman, for the record, you are absolutely right. You're absolutely right. One of the boards that comes before Commerce and Labor is the Contractors Board. And you know what? There's a provision there for homeowners who have been done unjustly to go before the Contractors Board and seek remedy. And if they can't seek remedy from the fees or from the money that's already in the Contractors Board's fund, then they have to get an attorney. Okay, they have to fight it. All right. Another one of the boards that comes before Commerce and Labor are medical boards. People have issues with a doctor or medical practice, and if something has been real egregious, they have to get an attorney. Recently there was a product that was recalled, okay? 3 different ways it was distributed, product that was recalled. If people want to get justice, they have to get an attorney. I knew that this was going to come up because the only way to fight something that will protect veterans and seniors and differently abled is to flip it and act like this is worse for the homeowner. I'm not saying that's what you said. Everything that we do, if there is an injustice that's done and we want to get justice, we've got to get an attorney. And I'll go back to what Sophia said, if you go through this process, you have a 50% chance of keeping your home. If you don't, you got a 100% chance that you're probably going to lose it. And some of the processes that we're talking about are already in place. Foreclosure mediation, the same judicial processes that we used during COVID with respect to evictions. And other things when people were fighting to stay in their homes. So, we're not talking about, flying to Mars and then coming back with some obtuse law. We're talking about using what's already in place to help those people, okay? Everything that we purchase, everything, okay? There's always a chance that we're going to get the short end of the stick. And we have 2 choices. Live with it, suck it up, or go to court. Some people suck it up. Some people say, well, this is important enough to me to go to court. And that's all we're saying. We're saying the same process that's in place. If you buy a tube of toothpaste and it's acid in there, you go to court. That's all we're saying. Do you have to go to court? No, you don't have to go to court now. You're right, okay? But the extra layer of protection, that's what I'm talking about. Once upon a time, we didn't have airbags. We figured out if we have airbags, you can protect and save people's lives. That's all we're talking about. Help somebody save their home.
Thank you. Okay, looks like Senator Krasner has a question. Go ahead.
Thank you, Chair Scheibel. Thank you for your presentation. Mr. Norman, I just have a quick question. Does the Legal Aid Center of Clark County, Southern Nevada, provide free legal services to seniors?
Jonathan Norman, for the record, yes.
And does Washoe County Legal Services in Washoe County provide free legal aid to seniors?
Yes.
Thank you.
Thank you. Are there other questions from other members? I have a few of my own. I know that we are coming up on a time constraint, though, so I'll try to keep it brief. I just want to make sure that I have a full understanding of the bill. And one of the things I want to clarify is, Senator, if we could just stop these foreclosures over fees, that would be a preferable solution to you from a policy standpoint, right?
Yes.
Okay, so this is our second choice option, is SB 175.
So SB 175 is second choice, yes. Okay, but it's because I'm trying to make sure that there's the protection in place. And to my other colleague, Senator Stone, he said there are a lot of good ones. Guess what? There are some that aren't so good. And the only reason there are stop signs when there's traffic going in the opposite direction is because everybody ain't gonna stop. That doesn't mean you take down the stop signs. That means you tell people, if you don't stop, you're gonna get fined. You're gonna get a penalty. That's all we're saying.
Exactly, and I totally understand that. So I just want to make sure that we were all looking at this the same way, understanding that we're not coming from a place of saying that this process is inherently fair or that, people inherently deserve to have their homes foreclosed on in these circumstances. But given that landscape, you're trying to do a couple of things in this bill. And reading through it, I have identified kind of 3 major things, and I want to make sure I'm not missing any. The first one has to do with the actual foreclosure process. And, this bill takes foreclosures for veterans and their family members and people over the age of 62 and people with disabilities out of the non-judicial process into the judicial process, and also provides them with certain notice about it. That's the first big section that I see. The second section of the bill, or the second priority of the bill that I see, is strengthening the requirements for HOAs to do repairs in and around the community. And then the third section that I see is reducing that threshold from 80% to 60% for a vote of the members to dissolve the HOA. Am I missing anything?
No, that's basically it.
All right. And I wanted to know if we already have any of these things, the judicial foreclosure for other groups of people or in other circumstances?
Currently, we do not, unless I missed something. Currently, anyone else who's not included in the bill, is that correct?
Jonathan Norman, so are you asking, are there other situations where we set aside classes of people like veterans, disabled? I am not aware of any where we tease out foreclosure rights by those types of categories.
Okay. And I also wanted to get a little bit better understanding. I know we've been over it many times in this committee, so I don't want a long explanation, but just a brief explanation. When a foreclosure goes to the judicial foreclosure process, I assume that you don't walk into court on the very first day and the judge rules and says, okay, you win, you lose. I assume that there is A, some kind of fact finding, B, some kind of discovery, and C, some kind of opportunity for negotiation. And I'm wondering if you can just educate us a little bit about that process and whether the negotiations are common and what they might look like.
So I think, or Jonathan Norman for the record, I think there's a lot of negotiation and it tracks general civil litigation. So there is a period of discovery, there can be interrogatories, requests for production of documents, and then there's an opportunity for mediation. And so I would say there are a lot of opportunities to resolve it, especially if there is a mortgage and the mortgage company is at the table and can make the HOA whole through a settlement agreement. And then they would be putting what they paid out into a settlement agreement with the homeowner.
And like other forms of civil litigation, do the majority of cases settle?
Jonathan Norman for the record, yes.
And I am surmising from the testimony that we've heard so far that lawyers, both retained attorneys and attorneys who provide services to indigent people, get involved in that judicial foreclosure process, but it would be unusual in the non-judicial process for an attorney to get involved. But I'm thinking, and please correct me if I'm wrong, because it's not my area, but kind of the impression that I'm getting is that if I'm a person going through a non-judicial foreclosure and I go to 2 or 3 different, consumer advocacy attorneys, they're frankly probably not going to take my case because it's a non-judicial foreclosure. Nobody pays attorneys to go fight with their HOAs, and even indigent services are probably maybe they're a different category. So maybe I shouldn't be lumping them together. But am I correct in my assumption about contract? What am I saying? Retained attorneys.
Jonathan Norman for the record. I can only speak to legal services, and we get involved in any case. So we would try to, if that case came in non-judicial foreclosure, to reach out to the HOA and see if there's an ability to reach an agreement. But I can't speak for the private bar.
Sophia Romero for the record, excuse me, Senator, Chair. If somebody were to come in with a non-judicial and they, gotten a notice of default and those type of things, it would be harder to retain a private attorney.
That makes sense to me. And those are my questions. It looks like members of the committee have a few more questions. Go ahead, Senator Orenshaw.
Thank you. And I think my question's for Mr. Norman. Mr. Norman, I don't know if you have either experience in other states where HOAs don't have this non-judicial foreclosure process, but I'm just wondering, either from your experience or from learning from other, legal aid attorneys in those states, do you find that when there are these kinds of foreclosures, when someone's, maybe paid off their mortgage, but there are fines, that they've been able, through the judicial foreclosure process, to save their home and to not lose what they've spent so much of their life trying to keep?
Jonathan Norman, thank you for the question, Senator Orenshaw. Yes, I think in judicial foreclosure, there's just so many more opportunities to get off the path to a bad outcome, whether that's in not every state has programs like mediation for foreclosure, but there are different opportunities in settlement. And certainly, as litigation develops, and you need to be frank, the cost of litigation goes up as litigation develops. So, for example, if you survive summary judgment, the impetus to settle a case is really high. So I would say in foreclosure generally, when you have judicial foreclosure, there's a way better likelihood of settling that case and having the consumer maintain their home.
Thank you, Mr. Norman. Thank you, Chair.
And Senator Nguyen.
I meant to ask this earlier. You had mentioned at the onset of your presentation, Senator Spearman, that we have some protections in place for active or deployed military members. What kind of protections do they have? Do they have a judicial foreclosure, or is it just other protections? Or did I mishear that?
No, I hope I'm not misquoting, but there is the Servicemen's Relief Bill, I think it is, and anyone who's on active duty, then that can't happen. Those same protections don't exist for veterans. It's a federal bill. It's a federal bill.
And then in that federal bill, and I don't know if you know this answer, would this emulate that? Like, I think in the federal bill, you have to tell, like, your HOA, or you have to tell your mortgage lender that you are active and you are deployed. You have to proactively do that. Would you have to do that same? Would you want to emulate that here? How would the HOA know that you are a veteran? How would they know that you are elderly? How would they know you're disabled? How would that process work? Would it be similar?
Yeah, it's voluntary, but in the bill, there's also a clause in there that says make a reasonable attempt to find out. In the bill that we had last time, when people join an HOA, one of the things that HOAs should be doing now is asking them, do you want to receive your information via mail or via the internet? Okay? And so it's a simple question. And most of the time, if there is a VA loan, that's a hint.
Thank you.
All right, and with that, we will move on. Oh, I'm so sorry. Go ahead.
Sophia Romero for the record. Just to follow up to your question, also on the credit application, their date of birth, their social security number, all their identifying information is on there, and usually they do have a box to check if they were a veteran.
All right, I think that brings us to the end of questions. Thank you so much, both for the presentation and for your patience with us answering our myriad questions. We will move now to testimony. I am going to start with just half an hour of testimony in each position. I think that will allow us to hear from everybody, and I'm going to keep you to the 2-minute window, and we will start with testimony in support. Anybody in Las Vegas or Carson City wishing to give testimony in support is invited up to the table now, and I ask that you make your way there and go ahead whenever you're ready. Sorry, we'll start in Carson City. I'll let you know when we're ready, Vegas.
Good afternoon, members of the Judiciary Committee. Chair Scheibel, I am Tony Grady. I spent 20 years in the United States Air Force, and I would like to speak for AB 175. One reason that I would like to speak for it is that there are many things that can happen with an HOA. I happen to live in an HOA right now. I was on the HOA board. So I would just like to say that I do not think that it is in the interest of the veterans. It's not in the interest of settling things to go into non-judicial settlement if there's a problem with the fees, dues, or whatever else. I say that from the standpoint of seeing how HOAs operate, and also from the standpoint that I would like to say that when you're speaking about our veterans, we are talking about people that have a lot of attention to detail. So if something happens and they have a problem, I think there are better ways to settle it. So I would like to speak for the bill. Thank you for listening today.
Thank you, Jamie Coghran on behalf of the NJA. We're here in support of the bill. We appreciate Senator Spearman and Assemblywoman Thomas bringing the bill. To echo their concerns, it is someone's most valuable asset. It gives them an extra layer of protection. and because of that, we support the bill. Thank you.
All right, I don't see anybody else coming to the table in Carson City, so we will go to Las Vegas.
Hello. Oh, okay. Hi. Good morning, everyone. My name is Jean, and I'll tell you a story. It's a real story. My dad is a retired veteran with Alzheimer's. He had 2 strokes, and he owns, some rental properties, quite a few rental properties. He has several tenants, and in January 2023, one of his tenants texted a photo of a 3-day notice taped to his door, the tenant's door. And it just basically said that, they were evicting that tenant. It was from the new owner. He thought, was this a hoax? The mortgages are always paid, they're paid on time. And he sent checks to the HOA and the collection agency for dues throughout the end of the year. But, and he was waiting for a response. They sent almost $4,000, and the HOA fees are only $15 a month. So, but they received no response, so he thought, oh, okay, this is fine. This property must be fine. Then 6 months later, it was foreclosed without his knowledge. So how could a $15 a month HOA fee turn into a foreclosure without his knowledge? Some of the months, the fees increased over $1,000. HOAs, they exist throughout the country. We're not asking for the dissolution of HOA dues. We're just asking to slow it down a little bit, especially for seniors that have Alzheimer's. Because also in my dad's case, he was visiting my mom every day in the hospital since December 2021. So he was depressed. He doesn't make the right decisions. I have power of attorney now for both his the properties and his health. But basically, the HOAs and the collection agencies, they charge high late fees to sometimes over $1,000 a month. HOAs ignore homeowner calls and requests to discuss fees. They ignore homeowners' checks and letters. Notices are sent from the HOAs that I've heard several people, they look like junk mail. They just come in white envelopes. And
you have reached 2 minutes if you could wrap up.
Okay, so basically, these groups can be targeted because he has a lot of, the home is worth $400,000, the equity is $300,000. He only has $125,000 left. We have an attorney, but who knows if we're going to win. So, I came here to speak up for the seniors and veterans and the disabled because as I own an artificial intelligence company, and they can be targeted.
Thank you. Thank you for your testimony.
Thank you.
I don't see anybody else coming up to the table in Las Vegas to give support testimony, so I don't think. Okay, so we'll go to the phones for support testimony on SB 175.
Thank you, Chair. If you would like to offer testimony in support of SB 175, please press *9 now or raise your hand in the Zoom client to take your place in the queue. Thank you, Chair. There are no callers wishing to offer testimony in support of SB 175 at this time.
All right, then we will move to testimony in opposition to SB 175. I'll invite anybody wishing to give opposition testimony to come up to the table in Carson City or in Las Vegas, but we will start with Carson. You can go ahead and get to the table in Las Vegas. We'll let the people in Carson City speak first.
Madam Chair, thank you. For the record, my name is Garrett Gordon, today representing CAI Nevada, who represents thousands of associations in Nevada and across the country. We strongly believe that this bill, as written, will increase costs to associations, resulting in increased assessments to homeowners, both homeowners who are in arrears, as well as to those associations and homeowners as a whole. For example, number one, replacing non-judicial foreclosure with expensive judicial foreclosure, we again believe, as heard by a few questions earlier, it will result in tens of thousands of dollars of more expense, when we do believe there's a cheaper option. Senator Orenshaw, when you were an assemblyman, we worked on mediation back, 4 or 5 sessions ago. A homeowner has a right to mediation with the real estate division. So in the event of a dispute between a homeowner and their HOA over CC&Rs and a foreclosure process, they can go through a cheap mediation process to have a third-party, non-biased mediator rule on the item. There's also the avenue to go to the Common Interest Community Commission. You can file a complaint. There's an investigation that occurs, and you go before that commission, who also has the ability to resolve it or come up with a settlement. Number two, as far as expense, Chairwoman, you mentioned kind of 3 topics in this bill. I think there's also a 4th that I would point out, that now associations could be ordered to pay punitive, treble, or special damages. As all the lawyers in the room know, those punitive damage can be tens, if not hundreds, if not millions of dollars. Who would pay those? The homeowners. How? By a special assessment. And either they'd have to come up with the money to pay the special assessment, or their homes would be liened for that special assessment. So we do not believe that treble, special, or punitive damages are appropriate for a nonprofit volunteer board or their association. And 3, the reduction to disbanding association. There was a very good question, who would pay for that? Likely city and counties. If the association is disbanded, who's maintaining the roads? Who's handling the snow? Who's paying for the landscaping? Who's handling the gates? Cities and counties would have to step in and take over that expense, likely with a special assessment. So we have many concerns, Chairwoman, and I would always, as you know, over the years, come up with a solution or a compromise. Senator Woodhouse, back in 2019, passed
So
SB...
sorry, that is 2 minutes.
Okay. I'll happy to answer a question on the task force if you have want to hear about that option.
Okay.
Thank you.
Chairperson Scheibel and distinguished members of the committee, thank you for allowing me to testify in front of you in opposition to Senate Bill 175. My name is Jeffrey Lofi, and I'm a homeowner and board member of Miramonte Homeowner Association in Sparks, Nevada. Mr. Ira Hansen is my senator, and I appreciate him being here. I'm also a member of the Community Action Institute Nevada chapter and a member of a Legislature and Action Committee. Under SB 75, I am one of those vulnerable people. Although I did not spend any time in the military, I am a veteran of the law enforcement for 29 years, where I upheld the Constitution of these United States and the laws of my city and state. Due to an injury to my leg, I am medically disabled, and I am 68 years old. Requiring a judicial foreclosure in lieu of non-judicial foreclosure is not actually affording a protection to persons with a disability or persons who are seniors, because SB 175 will increase the collection costs passed on to those households from the limited non-judicial foreclosure fee of only a regulated non-judicial foreclosure amount of $3,120. If it went to a judicial foreclosure, and the amounts could potentially be greater than $20,000. Thus, the bill will increase the cost of collections against an alleged protected household, and thereby the funds that the delinquent household would need to raise to pay off their debt. Being a senior citizen, my home is in a family trust. This bill would force my family to retain an attorney to represent the trust in court in case I was ever foreclosed on or in a lien. Again, this further increases the cost imposed on a delinquent senior that SB 175 improperly indicates it's trying to protect. As for my fellow neighbors and the members of my HOA and being a fiduciary for them, as I am a board member, forcing associations to take on costs of a judicial foreclosure for tens of thousands of dollars to recover delinquent assessments would be financially crippling. Meanwhile, if the association...
I'm sorry, that's 2 minutes.
Thank you very much.
Thank you.
Thank you, Madam Chair and members of the committee. Josh Hicks with McDonald Carano. I'm here today on behalf of the Nevada Home Builders Association, the Southern Nevada Home Builders Association, and the Builders Association of Northern Nevada that collectively represents the home building industry throughout the state. Our opposition is really focused on two sections, Section 5 and Section 9. Section 5 of the bill is the section that allows the voting threshold to dissolve a common interest community to be reduced from 80% to 60%. That is a concern because these common interest communities are often organized and established by the developer or the builder from the beginning. A significant amount of time and resources and effort is put into that. And the desire in doing that is to have longevity and quality in that community. And we want to make sure that homeowners in there have high quality homes that will last for a long time and will have a lot of their upkeep and issues in common elements taken care of. The idea that that could be dissolved more easily is problematic. It could impact the quality of the entire community, and there's issues there. If that were the case, you've heard some comment about what happens if a CIC dissolves, and that's true. The county or city could take on some of those obligations. Some jointly owned obligations, for example, roofs or even walls in condominiums can become tenants in common. And that requires cooperation with the neighbors if there's any kind of upkeep or issues there. Section 9 of the bill is the bill that increases the damages for actions against an association. The home builder's concern there is that that will increase insurance costs. Anytime insurance policies are often priced by the amount of exposure, and having significant exposure to more damages is going to increase those insurance costs. It leaves less money available to the HOA to do the things that they should be doing with respect to the common elements. So those are the reasons we oppose the bill. Thank you for the time today.
Thank you. Anybody else wishing to give opposition testimony in Carson City is invited to the table, and go ahead whenever you're ready.
Thank you, Madam Chair. My name is Donna Zanetti. I'm an attorney. I'm 62 years of age, and I also have a disability, and I'm a member of the Nevada CAI Legislative Action Committee. My job today is to provide some facts about HOA foreclosures over the past 2 years. These numbers come from the U.S. Census, the Nevada Real Estate Division, and county recorders' websites. As of July 2022, there were 3,584 HOAs in Nevada, comprising over 616,000 units. This represents 47% of the state's housing stock. The overwhelming majority are in Clark County, 2,884 HOAs made up of 504,580 units. The Clark County Recorder does not have a separate category for HOA foreclosures, but working from the recorded notices of sale, which is the final notice before foreclosure, there were a total of 240 HOA notices of sale. This represents 0.5% of the HOA units in Clark County. By comparison, lenders recorded over 2,800 notices of sale during this period. There were only 9 HOA foreclosures in Washoe County and 0 in Carson City, Douglas, Lyon, or Nye counties. Together, these cities and counties have a total of 682 HOAs. One of the categories of persons this bill seeks to protect is senior citizens. If this group were in need of greater protection, one would assume that the foreclosure rate in senior adult HOAs would reflect that need. They do not. Sun City, Summerlin, Aliante, McDonald Ranch, and Sierra Canyon are all senior adult HOAs. Together, they represent more than 13,000 units, but with only 2 foreclosures over a 2-year period. There are over 202,000 veterans in Nevada, but I could find no information on how many live in HOAs or have been subject to HOA foreclosures. In summary, legislation should be based on facts, and the facts do not support this bill. Thank you.
Hello, thank you for the opportunity to speak. My name is Alex Echo. I've been a HOA board member for about 25 years now, and I'd like to thank Senator Stone for the information and knowledge that he shared with us. He was right on the money. Okay, I think the extra protections for veterans and seniors is a wonderful sentiment. However, presently, vets get VA medical, GI Bill, military retirement. Seniors get Medicare, Social Security, but it's paid for by the federal government. Now, why should we make HOA members, the neighbors of the seniors, pay for the additional benefits they get? Why do we put this cost on a small group of people? For example, if a veteran gets his car repossessed, should we make his neighbors pay the payments so he can keep his car? Their neighbors also struggle. They're working class people. They have issues, they have problems, and they have stuff happen also. So I think if Nevada wants to give more benefits to these groups of people, then the state of Nevada should pay for them and not make their neighbors pay for them. Thank you. That's my comment.
Good afternoon. My name is Tanya Bates. I am representing CAI Nevada LAC. I am a community manager with the Management Trust, representing over 15,000 constituents in 6 Nevada counties. I reside in Senator Hansen's district. I am hearing impaired, which is considered a disability under this bill. You may notice my speech impediment due to my impairment. My parents purchased my childhood home in Las Vegas in 1988 with a VA loan. My father is a Vietnam Air Force veteran. I respect Senator Spearman's passion for this vulnerable population. For clarification, this bill does not prevent an association from foreclosing on a veteran, senior citizen, or person family with disability. It merely moves it from a non-judicial foreclosure to the more expensive for judicial foreclosure. Additionally, we cannot foreclose on a home because you painted your home the wrong color. We cannot foreclose on fines in an association. I'm supposed to speak on section NRS 116.41095, but Senator Stone covered that for me. My next step is when it comes to Senator Hansen actually once resided in an association that I dissolved in 2012. In that situation, the Washoe County annexed in the roads. Those homeowners were assessed a $21,000 special assessment to pave the roads and for Washoe County to maintain them. We still had to meet the threshold of the 80% vote for that to occur. That is one of the only associations that have been dissolved in the state of Nevada. I know Donna Zanetta has met that threshold on another way. As a community manager with a disability, it's section 10 of this law, you are asking that should my spidey senses fail me on a specific day, that the Attorney General can take my license away. That's my livelihood, that's how I support my family, that's how I pay my thing. I don't think this is a just, fair resolution, and I do understand Senator Hansen's passion. I'm just as passionate with her.
All right, thank you. Is there anybody else in Carson City wishing to give opposition testimony? All right, go ahead whenever you're ready.
My name is Rhonda Tyson. I'm the president of a 100-unit condominium association in Reno. We don't keep demographic information, nor are we an age-restricted community, but my guess is upwards of 95% of our membership would fall under these categories. 100% of our members, as well as every other homeowner in Nevada, in an HOA or a condominium association, is put at financial risk should this bill pass into law. I have to say, I was concerned that you aren't concerned about association attorney bills. Every time my attorney or association attorney reads an email, it costs us money. Every time there's a telephone call, a request for advice, it costs us money. Who pays that? The owners pay that. And in this case, you've got a double whammy on the veterans and the seniors and the disabled people, because they'll have to not only pay their own attorneys, but they will have to pay their share of raised assessments, because it will cost money and it will take time. One last thing, I devote probably a minimum of 20 to 40 hours a week, volunteer time to my community to honor my commitment under the laws of Nevada, which is to make the best business decisions for my association. And this bill threatens me not only with treble damages, punitive damages, but you're going to write me up for a misdemeanor if somehow or another things don't go the way somebody thinks they should go. One last comment. Nobody wants people to lose their homes, and that includes board members. We want people in their homes. Do not raise the costs for keeping people in their homes. Let us work through the existing avenues that we currently have to keep people in their homes. It's what we all want. There should be no question about that. Please do not let this bill get out of committee.
Good afternoon. My name is Lori Olson, and I'm a Nevada Certified Supervising Community Association Manager and have been for 20-plus years. I'm considered a subject matter expert. It's all about the law. This isn't about emotions. It's not about zip codes, not color, not race, not economic status. It's about the law. My job as a community manager is to follow the law that the legislators have written for us. If I don't follow the law, I could end up in front of the Common Interest Community Commission where I could be fined thousands of dollars or I could lose my license. I think it's important to note that it is not dues. They're assessments. Assessments and fees are completely different. So I think it's good for you guys to understand assessments are one thing, fees are another, and there are no dues in HOAs unless you belong to the fitness club. Attorneys charge by the hour. To think that an HOA won't have to raise their assessments because of attorneys' charges is one of the most ridiculous statements I think I've heard, and I'm sorry about that. I assist a 161 mobile home unit HOA. They're all retired. When we raised their assessments up $3 a month to $40 in January, it actually caused a hardship for many of those homeowners. They have $18,000 in AR. Their accounts receivable is in excess of $18,000. Why? Because we're following the law, and it takes that long to get through a process to collect your money. I can tell you that one judicial foreclosure for that HOA will put them under. They'll have to have a budget amendment, and they won't be able to afford their legal fees. Smaller HOAs, they just don't budget for legal fees. They don't have the income. There are things that the county forecloses when you don't pay your taxes. I'd be interested in knowing what the county does if you're elderly, if you're a veteran. And there are we have to have by law a written collection policy. The NRS 116 tells us exactly what has to be in that policy, and that's exactly what we follow so that we don't end up in front of the commission. Thank you.
Pardon me. Thank you for hearing me. I'm Neil Strocchio. I have a slight speech impediment too, so I'll try and get through this. I'm also a board member for over 10 years now, and I see this bill as a way to both undermine the ability for associations to fund their day-to-day expenses and future repair and replacement obligations, while at the same time force them to make repairs on a timeline that would be increasingly difficult. Non-judicial foreclosure is already tightly controlled by existing law, and protections are in place for service members and their families. This collection option is an effective tool in discouraging homeowners from becoming delinquent in their assessments, and in fact, non-judicial foreclosure is used only as a last resort in a very small percentage of delinquencies. Most often, the eventuality of foreclosure is enough to encourage homeowners to bring their accounts current. By eliminating this option and allowing only judicial foreclosure to recover delinquent assessments, and only in certain circumstances, an increasing number of homeowners may no longer see the need to be diligent in paying these assessments on time or even at all. The much increased pay-as-you-go costs of judicial foreclosure through an attorney will only exacerbate the situation. Property values for a high percentage of your constituents could plummet as their homeowners associations struggle under the weight of decreasing income and increasing costs. This could also create a ripple effect in the greater real estate market. I wonder whose interests this bill serves. I really do. As I see it, there is not one good argument for giving this bill even the slightest consideration.
And that's 2 minutes.
Okay,
So
I
thank
hope you will make sure that none of these provisions ever make their way into common interest community
Thank you.
legislation.
At this point, we are going to switch over to our testifiers in Las Vegas, and please go ahead whenever you're ready. You'll each have 2 minutes.
Madam Chair and members of the State Judiciary Committee, my name is John Leach. I'm an attorney in Las Vegas with the law firm of Leach, Kern, Gruco, Anderson, Song. We have offices in the North and the South. I'm here today at the request of the Legislative Action Committee for CAI. And just as an aside, I've also been involved with associations since 1988, before this law existed, and I have been involved in virtually every legislative session since the act was adopted. And it's kind of disturbing that every 2 years we have to come in and address misunderstandings and misinformation that you're pounded with before you have to make a decision. I've heard people say that foreclosures are immediate and fast, and neither are true. This is one of the most regulated areas of the law, and has been changed many times over the past several years to address that. For example, the Service Members Civil Relief Act, which is a Nevada statute, not a federal statute. In fact, the Nevada statute is more beneficial to veterans and to those that are serving, because it extends a year after their service. But it's highly regulated, not just by Nevada, but by federal law. There are federal requirements about notices that must also go out. I did a little timeline here, and unfortunately I don't have the time to go through it with you, but simply to say this, that if you are very quick and you follow every step and you do it immediately and you don't skip any beats, you're talking at somewhere between 13 to 16 months, and that's if you don't have a hiccup along the way before you complete a foreclosure sale. And the number of notices that are given to the homeowner along the way is somewhere between 6 to 9, both regular and certified mail. So when a person says that they're never given notice, it's simply not true. The notices are given repeatedly and frequently as required by the law. And then more importantly, the payment plans. The very first notice that the law requires to be sent not only tells them to let us know if you're a service member, but also offers them a payment plan. You are required by law to offer a payment plan. And those payment plans do not have to be long periods. They can be 3 months, 6 months, short periods of time, because there's only 2 or 3 months owed at the time. But as this process proceeds and then the amount gets larger, I've got associations that are right now accepting 3-year payment plans, 4-year payment plans to deal with the past due balance, because it's more important, as was testified earlier, that we keep them in their home rather than lose them.
And that's 2 minutes.
Okay, can I just say this? If you really want to do something for seniors, for veterans, and for the disabled this session, then you will not allow this bill to go anywhere, because all it will do is make those people pay more because of the judicial foreclosure process. It's not even an issue. It's absolutely clear.
Good afternoon, committee. My name is Attorney Greg Kerr. I'm an attorney with the law firm of Wolf, Rifkin, Shapiro, Shulman, and Rabkin. I'm also a member of the CAI Legislative Action Committee. My objection that I'm going to speak about 2 particular issues of the bill. One, the reduction of the termination vote requirement from 80 to 60, and also the punitive damage issues. As to the reduction of the voting requirement from 80 to 60 to terminate the association commerce community, that means up to 40% of a community can have its membership rights and privileges taken away by what's not really more than a majority vote. And as raised earlier, who's going to take care of the pool, the parks, the playground, the clubhouse, the streets, the landscaping? Who does that fall on? City governments? Sure, if they're willing to do it, but it's not going to be for free. Many of the people that are described as vulnerable, the veterans, the elderly, the disabled, they benefit. Their properties benefit from being in an association, and they can have those membership privileges taken away much easier under this bill. As to the punitive damages, it's important for the committee to recognize associations do not have any money outside of the money that's paid to it by assessments from homeowners. So when a punitive damage award is awarded against an association, it's not, quote unquote, the association that pays it, it's the homeowners through special assessments. And under NRS 116-3117, judgment creditors have a statutory lien against not common areas, against the actual homes themselves. So if a homeowner is unable to pay a special assessment, guess what? The judgment creditor can foreclose those homes. Imagine some of those owners that cannot pay a special assessment are elderly. Imagine a veteran not being able to pay a special assessment to pay punitive damages, or somebody who's disabled. They will lose their homes, not to the association, but to a judgment creditor. So please vote this bill down. It only exposes all homeowners that live in associations to punitive damage awards, not the association, because that's not who pays it. Thank you.
Madam Chair and members of the committee, my name is Eric Theros. I represent the Nevada Association of Community Managers. As a community manager, we are tasked with looking out for every homeowner within an HOA while also protecting the overall organization. Being the community managers are the boots on the ground that help facilitate and implement whatever laws the state passes. We have true perspective of the potential unintended ripple effects of bills just like this one. Senate Bill 175 could be detrimental not only to the common interest communities in general, but it would be detrimental to the majority of owners living in that same community for a multitude of reasons. The idea that requiring judicial foreclosures would provide any relief to homeowners couldn't be further from how the actual rules and laws would affect things. Currently, the only truly affordable way an association can perform collections of delinquent accounts is through the non-judicial route, as that route allows the association to engage a professional collection company that agrees to collect their fees when they collect on the debt from the homeowner responsible for the debt. So whether a community is small or large, everybody can afford to enforce delinquency recovery. However, judicial foreclosure could be anywhere between $20,000 and $80,000, and that's only if it's lightly contested. Some common interest communities don't even have an annual budget of $45,000, yet alone be able to spend that much on one single individual account. Who would pay for that? Who would pay for that $45,000? A special assessment, which would not be fair to the over 90% of owners who aren't delinquent. In addition, another portion of the bill would suggest modifying the current 60-day right of redemption period to a full year, and this would adversely affect communities through the entire state. If an owner walks away from a property and leaves it vacant, the risk of squatters is more and more prevalent. Having a one-year redemption period means that those homes would be vacant for an entire year, just sitting there to attract the next transient group of squatters to do who knows what in the unit. People who buy a property will not make the interior repairs and put it on the rental or sale market if they don't even know if they'll get to keep the property a year from the sale date, and that'll create a huge problem. Thank you.
Okay, thank you.
Hi, for the record, Stephen Parker. I represent Cameo and First Service Residential. You've heard a lot of testimony about the damage this would do to HOAs and the homeowners within the HOAs. And while I agree with that, I won't repeat that since it was well articulated. I think perhaps the most damage done, though, will be the group of individuals that this bill is purporting to help. With the exception of one case that you've heard in testimony today, the foreclosure process for these three groups of individuals was not disputed as wrong. It was disputed as shouldn't be happening. In other words, they did owe, they needed to pay, but they didn't like the non-judicial foreclosure process. That's the case with the vast majority of delinquent accounts. There isn't an issue of, is it wrong? Do they really owe it? They owe it, but for a variety of different circumstances, they aren't able to pay it. Part of the non-judicial process, advantages of that process is that it's substantially cheaper than the judicial foreclosure process. So if you have a disabled veteran who gets behind on his assessments and he goes through the non-judicial foreclosure process, as was testified, there are a variety of ways to mitigate and to discuss options, payment plans. That happens even before they get to collections. The question isn't, are they delinquent? That, as I said, is, and it hasn't been argued here today, they are. The question is, what's the most efficient way to resolve that? And that is a non-judicial foreclosure. While no one likes that process, it's the process currently afforded by the law to resolve that. To go with a non-judicial foreclosure, understanding that most of the cases that are delinquent are really delinquent, to go with a different approach just means it's going to be resolved either in a payment plan or a foreclosure, just at significantly more cost to those three groups of individuals than it would if it were in a non-judicial foreclosure process. Thank you.
My name is Lyle McKenzie. I am a senior disabled veteran who retired from the United States Army after proudly serving my country for 22 years. I am also president of the El Dorado Neighborhood Second Homeowners Association, located in North Las Vegas, Nevada, Senate District 1. My community consists of 1,586 single-family homes. The impression I've been given earlier in the testimony given before this committee is that homeowner associations are lying in wait to foreclose on homes of veterans, the disabled, and seniors. I'm here to say this is nothing further than from the truth. In the 6 years that I have been president of my association, we have never foreclosed on a single home. In the rare case that a homeowner gets behind in their assessments, we work with them to establish a payment plan that is reasonable and manageable for them. This bill requiring collection actions to be taken to court would substantially increase the collection costs for the very people it proposes to help. All association members share the cost of judgments against the association, and allowing treble punitive damages for innocent mistakes would subject other veterans, seniors, and disabled persons to extremely high shares of any judgment rendered. Many of these people are already struggling to pay their bills, buy groceries, and pay other costs of maintaining a healthy life. To impose on them a share of any judgment would seriously degrade their health and cause irreparable harm. I urge you to not pass this bill out of committee. Thank you.
All right, at this point in time, we have reached a little over 30 minutes of testimony, so I am going to move to testimony in the neutral position. I invite anybody who was not able to testify today, either because we ran out of time or because they weren't able to be here, to submit their comments in writing. I read all of the comments that are submitted to the committee, and they're also posted in our official record on the Nevada Electronic Legislative Information site, NELIS, and I encourage all of my members to read them as well. At this time, we will move into testimony in neutral. I don't see anybody coming to the table in Carson City, but I do see somebody in Las Vegas, so we'll start with you. Please go ahead.
Good afternoon, Madam Chair, members of the committee. Sharat Chandra, Administrator for the Real Estate Division. Just testifying in the neutral, and if you have any questions. Thank you.
All right. I just realized I forgot to do opposition testimony on the phone, so I will extend opposition testimony for another 10 minutes to see if there's anybody on the phone wishing to give opposition testimony.
Thank you, Chair. If you would like to offer testimony in opposition to SB 175, please press star 9 now to take your place in the queue.
Cyrus, C-Y-R-U-S. I'm not sure if this is opposition or neutral. A lot of people made some good points. Personally, with the exception of condominiums, especially if it's detached homes, especially if you're looking for newer development, we should avoid dealing with HOAs and rely more on small city governments, particularly ordinances, and building more durable products for structures. Thank you so much.
Yes, my name is Lori Berger. I'm Senior Vice President for Eugene Berger Management Corporation of Reno. I'm also a member of the CAI Legislative Action Committee of Nevada. I'm in supervising CAM number 1731, so I'm one of the first, maybe one of the oldest. I appreciate the intent of the bill, but SB 175 targets mid-level employees of management companies like ours and puts our livelihood at risk for decisions made by others. I say this because the boards make decisions, and we carry out those decisions in an agency relationship. Most managers have no supervising authority over the accounting staff or others, or decisions made by boards in the collection process. There is already a chronic shortage of managers, and this bill will exacerbate that problem. It also creates a greater financial burden on all members, including vets, seniors, disabled persons, and the collection costs will become astronomical due to the judicial foreclosure requirement, treble, and punitive damage charges. As an example, our firm manages 20,000 homeowners associations in the state of Nevada, both Reno and Las Vegas. We do not have, nor is an owner required to provide any loan information to us. We have no information regarding age, gender, nationality, or any demographic information. In a 2-year period from 2021 to 2022, we sent 2,428 60-day notices to homeowners. Of this, 94% of the homeowners brought their account current, with no further collection activity required. Foreclosure is extremely rare. This is because our team is able to provide homeowners with information about their balances so that they can quickly resolve and avoid costly legal expenses. We explain why the account has become delinquent. We offer payment plans as required by law, and owners take advantage of this. Sometimes it's just a simple question the homeowner did not understand. The homeowner used their wrong bank account. The check never arrived. There's an NSF. They forgot to pay, or they simply been paying the wrong amount over time.
Ma'am,
We also
you're
said
at
the
your
homeowner
2
was
minutes.
required
I'm
to
going to
pass-
need you to go ahead and wrap up, please.
Okay. In my 44 years of experience, boards simply want the delinquency to be resolved. They do whatever they can to help the homeowner become current. Nobody wants a homeowner to lose a home. Thank you.
Yes, good afternoon. My name is Christopher Yerger. I'm a retired and disabled combat veteran with over 16 years combined homeowner experience in Nevada common interest communities. I strongly urge you to oppose SB 175 because it will harm homeowners. Common interest community homeowners, through their HOA assessments, fund the operation and maintenance of all common areas in their communities, up to and including the streets. When an HOA member fails to pay their assessments, the other members must all pay more as a result. It is always in the interest of HOAs to work with the homeowners to avoid foreclosures. However, requiring HOAs to pursue expensive judicial foreclosures or on delinquent assessments can cost HOA members tens of thousands per foreclosure. NRS 116 already provides a structured and lengthy process for HOA foreclosures. This bill sets up a caste system whereby certain categories of persons, regardless of financial status, are given more protection than other categories of persons. Existing law already provides protections for many in these categories. This bill will ultimately harm many of those it purports to protect. HOA boards, elected volunteer homeowners, along with licensed professional community managers, are accountable to the homeowners of the community. This bill seeks to impose criminal penalties against community managers for doing their job. This will ultimately increase the cost to homeowners. The election process, along with the remainder of NRS 116, provides adequate mechanisms for HOA and community manager accountability. The Ombudsman's Office, under NRED, directly funded by HOA owners, provides adequate oversight of HOAs and recourse to homeowners. With nearly 617,000 HOA units across Nevada funding their own operations and infrastructure maintenance, these homeowners provide literally billions of dollars in municipal relief throughout Nevada each year. Reducing the percentage of votes required to terminate a common interest community in conflict with the CC&Rs of most communities makes no sense. This ignores the treatment of common elements after such a termination. The city or county will not take ownership of the infrastructure, certainly not without significant cost to homeowners. SB 175 threatens the foundation of HOAs, their ability to fund the operation and maintenance of their communities, and will ultimately increase the cost to homeowners of those communities. This bill is bad for homeowners and bad for Nevada. I strongly urge you to oppose SB 175. Thank you for your time.
Hi, my name is James Strasser. I'm a lifelong resident of Las Vegas. I'm a lifelong Democrat. I'm the son of a Vietnam veteran and 2 parents who died of cancer. I've worked for 17 years as an HOA manager in the Las Vegas Valley. I've approved every payment plan a homeowner has ever proposed to me. We make extraordinary efforts to contact homeowners in arrears by mail, certified mail, email, phone, and in person. I also serve on an HOA board. From those who have spoken in support of this bill, I've heard false testimony that the non-judicial foreclosure process is a fast one. It is not. From those who have spoken in support of this bill, we have heard stories of HOA disputes. Suffice it to say, every one of those stories has a different side to it. I want to touch on the glib way those who have spoken in support of this bill have referred to HOA assessments as dues or fees, like your gym membership or Netflix subscription. HOAs are responsible for streets, sidewalks, drainage swales, fire suppression sprinklers, and other infrastructure that must be maintained for the safety and welfare of the public at large. I managed a community with a sewer system maintained by the HOA that served 1,600 homes. Due to builder flaws, sewage flowed through the streets on several occasions, and thank God the HOA had the funds available to remedy the problem. Those who have spoken in support of this bill have commented that this bill will not let someone off the hook from paying their assessments, but this is false. It will let them off the hook for years until they sell or pass away, and functionally, for the HOA's function, this is the same. For the thousands of HOAs that are very small, 10 homes, 15 homes, 25 homes, once word gets out that you don't have to pay your assessment, a critical mass of homeowners will stop paying in many HOAs, and these HOAs will cease to function. Contrarily, for those HOAs that are large and can afford attorney's fees, the homeowner at risk of foreclosure will face severely increased fees that have been discussed several times today through judicial foreclosure. It will be a grave injustice to create a bifurcated system where owners in small HOAs are treated differently than those in large HOAs. I also want to mention the service members active duty protections that have been mentioned several times. In the decade plus this law has been in effect, I have received a handful of requests related to this law.
And that's 2 minutes.
I've only ever received falsified information from unscrupulous people using stolen valor to abuse the law, and this bill would invite much the same related to these protections. I strongly urge you to vote
All right,
against
thank
the
you
bill.
for your testimony.
Hi, my name is Lisa Jagel, and I am a community manager. Working in the HOA industry for over 10 years and owning a home with an HOA myself, I completely understand why people don't understand them and why they can have such a bad reputation. What I think most people don't understand is why we have homeowners associations in Nevada. During the extreme growth of our small city in the late 80s and 90s, it was determined that the city and county could not support the kind of growth we were experiencing, and HOAs were developed as a way to allow for the continued growth while removing the pressure from the local government. The basis for most HOAs are city and county codes that already existed, but in creating HOAs, the responsibility of performing inspections and enforcing those codes gets turned over to the HOA to manage. This is also true of the cost for maintenance of items like streets, street signs, and street lights, just to name a few examples. Just like in an HOA, there are city and county codes that prohibit someone from allowing their overgrown trees to cover street signs or from holding a yard sale every week. The difference is the city and county are so busy they don't have time to inspect and enforce the codes the way an HOA can, since they have management companies handle these administrative tasks. My point in the above is that rules about your property already existed long before HOAs were ever thought of, but HOAs are created to ensure that those codes are actually followed when the city and county are too inundated to follow through on those responsibilities. Inspections and enforcement are only a part of the responsibilities, though. The bigger issue is who is going to pay for all the maintenance to keep streets nice and to keep street signs and street lights maintained and operational. An HOA collects the cost necessary for these maintenance items from the owners in the neighborhoods that benefit from these items. Living in a community that has streets without huge potholes, with working streetlights and easy-to-reach street signs and well-manicured landscape helps sustain and even improve property values for the owners in the community. It's no secret everything in the world costs money, and maintaining an association is no different. If there are 10 homes and it costs $10,000 a year to run an association, each owner would need to pay $1,000. What if one owner can't or won't pay? Then 9 owners have to come up with the money to run the community, and now those other 9 are responsible for $1,111.11. What if 5
And that
owners
brings you to
decide
2
they can't or
minutes.
won't pay?
Thank you for your testimony.
Thank you.
At this point, I'm going to close the testimony in opposition to SB 175, and we'll go to testimony in the neutral position on SB 175. I'm not sure. I see somebody down in Las Vegas and you're holding up a card that I can't read. Are you here? Are you here to testify in neutral?
Neutral?
Yes, please. Go ahead. You'll have 2 minutes.
Good morning. My name is Susan Profit, and I'm Vice President of the Nevada Republican Club, and I'd like to thank all of you for your service today. As a landlord, my experience has been that the banks are often the primary problem, as was the case when my daughter became a recent fentanyl casualty. But I'm still neutral, even though it makes putting a lien on the property difficult. I'd like to point out the constitutional aspect of it, however. It carves out a special perks for different groups, so you might want to consider that. And on a lighter note, I'd like to request that our legislature take a few minutes to remind Howard Hughes and other HOAs not to break state and federal laws regarding election signs. Regardless of the contract signed, it's one sign per candidate, not per yard. And I had 6 lawyers and several of the judges confirm that here in Clark County. So I would appreciate that. We don't want to get these threatening calls again.
All right. Thank you. I don't see anybody else coming to the table in Las Vegas or Carson City to give neutral testimony. So we will go to the phone for any testimony in neutral.
Thank you. If you would like to offer neutral testimony to SB 175, please press star 9 now or raise your hand in the Zoom client to take your place in the queue. Thank you, Chair. There are no callers wishing to offer neutral testimony at this time.
All right. Thank you. Then that concludes testimony on SB 175. If the sponsor would like to come give any brief closing remarks, please go ahead.
Thank you, Madam Chair and committee members. When I brought this bill, I was well aware that I was going to run into a buzzsaw, and I did. But I still needed to bring it because I needed to raise awareness. Just a couple of things in terms of facts. I've heard several people testify that they were with CAI, Charlie Alpha India, for those of you who do phonetics. And on the website, www.cai-cap.com/about-us/. It lists there that they are a vertically integrated company with assets of $280 million. On an annual basis, HOAs nationwide collect $103 billion from homeowners. I've heard also that there have not been any foreclosures. In Reno, there was $1 billion of loss in Reno and Vegas based upon foreclosures, HOA foreclosures. And that was tied to foreclosures that were by HOAs. 611 foreclosed from 2013 to 2016, costing about $840 million loss in home values. Currently, I've heard people say that doesn't happen, but currently, right now, there are 10 homes per month. That's the standard foreclosure in Nevada. We look at what all of this means, and vertically integrated company is a company that owns the entire supply chain. And so I think that it's significant to look at that. HOAs, $103.2 billion a year from homeowners. An estimated 7,500 HOAs are large scale, meaning that they're not the small 50 homes, 100 homes that, many people talked about today. But most of them are larger. And I think you've heard several people talk about, I think it was like 20,000 homes or something like that. So I'm putting this on the record because I just need people to know we're not talking about a mom and pop shop, and nothing in this bill prevents people from negotiating beforehand. The bill is simply a way to say, if you're going to foreclose on a veteran, foreclose on someone who is 62, or foreclose on someone who has is differently able, then please, please, please take the extra step. And I know that there are several people who are anxious about this bill. And again, I have no illusions, but one thing that I am clear on is that I have made sure that I've gotten the information out, and perhaps at some point in the next millennium, there will be some standards set and some ways that homeowners can protect themselves. And I'd like to turn it over to my co-presenter now.
Sophia Romero for the record. We've heard from the opposition that this is a small percentage or a small number. Then if that is the case, the parade of horribles that they've put out here today is not going to come to pass. Additionally, we heard a lot of concern over punitive damages. Punitive damages are governed by NRS Chapter 42. There has to be malicious, fraudulent, or willful disregard, and I might be misquoting the last one because I don't have the statute perfectly memorized, but there has to be findings. A judge has to find that they did wrongdoing in order to award punitive damages, or a jury has to find that. So that it's not just, oh, magically you're foreclosing so you get punitive damages. That is not the case. So punitive damages have their own criteria. HOAs are legal entities, and as such, budget for legal fees as a cost of doing business. Additionally, because of that, they often have, as we heard earlier from previous testimony, they have attorneys on retainer. So they have already budgeted for legal issues. Some states require judicial foreclosure even for repossessing a vehicle. Before you can repossess a car in some states, you have to go through a judicial foreclosure process. We are not talking about a car. We are talking about someone's home. This is even more important, and we're talking about specific classes of people: veterans, differently abled, and elderly, or over 62. I shouldn't say elderly. Additionally, statutes do protected classes of people all the time. We protect certain groups of people just as a matter of course in statutes. And then everybody, I think, has basically said, we don't want to foreclose on a homeowner. Nothing is preventing the negotiations. But if nobody wants to foreclose on a homeowner, then why are we foreclosing on these homeowners? Let's just stop foreclosing on the homeowners. That's the bottom line. If HOAs would do everything in their power to have a homeowner stay in their home, especially these homeowners where there's equity or where the home is completely paid off. And we're not talking about a mortgage. We're not talking about paying back money that we borrowed to get the home. We're talking about monthly assessments that you can never get out of because of the HOA agreement when you bought into a community. And as somebody else mentioned, HOAs are part of the development with the builders. This is not like someone's like, oh, I bought a home and we're going to create an HOA and we're going to make sure all of our fences are pretty. They're already in place before you can even try to buy a home. I just recently purchased a home. I tried to buy a home that was not in an HOA. I couldn't do it because I couldn't afford it. It was $200,000 more. I can't do it. I had to buy in an HOA. With all of my knowledge, with all of my experience, with all of my fighting against HOAs for decades, I had to buy in an HOA. I didn't have a choice. That's what these people are up against. Thank you.
Thank you, Madam Chair. And I just want to read from the website because I don't want anyone to think that we made this stuff up. But this is from CAI's website. And this is to make sure that people understand we're not talking about small organizations, not talking about organizations that are not financially viable. From their website, About Us, founded in 2011, CAI Investments is an industry leader in providing real estate investment that's speculation opportunities with more than $280 million in equity raised. CAI develops and manages properties across key markets in the United States. We offer qualified opportunities, zones, and LLCs. Our business, CAI Investments, is vertically integrated real estate development. And so when we start talking about the HOAs, this is not intended to hurt small HOAs. This is not intended to hurt small businesses. What this is it is a bill to make sure that there's an extra step that goes into the process. That's all it is. Hope it gets out of committee. I don't know that it will. Hope that it passes. I don't know that it will. But God knows that I've done my best. Thank you.
Thank you, Senator. And could you just clarify, because I'm finding a couple of different organizations that utilize the CAI as their shorthand. What do you call it? Initials.
Yeah.
So the
It's the acronym CAI.
and the website that you're reading from, what is the full name of that organization?
CAICap.com.
But what's the full name of the organization?
That's what they. Oh, God, I can't. There we go. It just got CI Investments.
So, okay, so I think you're reading from the CAI Investments website, and I think our people here testifying are from the Community Associations Institute.
Yeah, and I'll have to bring you the information, but I believe that they are connected because I just had somebody to do the research, but I'll bring you the information.
Okay, thank you. All right. That brings us to the end of this hearing, and I will now close the hearing on SB 175. And that brings us to the last item on our agenda, which is public comment. Anybody wishing to give public comment is invited to the table here in Carson City or in Las Vegas. It looks like we have somebody in Las Vegas. As a reminder, public comment is also limited to 2 minutes and can be about anything that the judiciary covers that is not related to this bill. So, okay. Looks like we're finished down in Las Vegas and in Carson City, unless there's somebody here for public comment. Okay, go ahead.
Donna Zanetti with the Community Associations Institute Legislative Action Committee. Community Associations Institute is at caionline.org. The entity that Senator Spearman was referencing is not CAI, Community Associations Institute. Thank you.
Thank you. Anybody else here to give public comment? Okay, as a reminder, public comment is about something. It looks like somebody tried to say something into the microphone in Las Vegas, but we weren't able to hear you. I'm going to be cutting off public comment at this point. Okay, if you want to be heard, you have to turn on the microphone, but you also have to sit down. You have to give us your name.
I was just going to say, I'm Jean, and Jean Coquilia, and CAI is a lobbyist group that.
Okay, we are done with public comment because we're not fighting over the acronym CAI after the bill hearing. I assume that those of you who testified will be able to provide me with some kind of documentation about the group that you actually do represent. Senator Spearman has promised to provide me with a report on the organization that she referenced in her testimony, and I have every confidence that this committee will be able to determine how that might be relevant to their weighing of the testimony that we heard today and making a decision about this bill. We still have the phone line open for public comment, so if there's anybody wishing to give public comment on the phone line, now would be the time.
Thank you, Chair. If you would like to offer public comment today, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers wishing to offer public comment at this time.
All right, then that brings us to the end of today's meeting. We will be back same time, same place tomorrow, and until then, we are adjourned.